Hello everybody, welcome to 21st Century IAS Academy Delhi Campus C.A.R.E Initiative, Current Affairs through Reverse Engineering. This is Goli Varsha. Let us look into the first article for the day. Washington warned India against plot to kill Panun in US, says a report. And this is relevant in GS2. Alright. Now what is this article saying? The article says that the Washington has warned India against a plot to kill Khalistani separatists Mr. Panun. All right. This guy is the founder of the banned terror designated group, Six for Justice. All right. And the Six for Justice advocates for a separate state of Khalistan for Sikhs. Now, for prelims, one thing, Khalistan. Second thing, this guy's properties are confiscated by the National Investigation Agency under Unlawful Activities Prevention Act. Alright, so these two will be important for prelims. Okay, now what is Khalistan area according to the map that they are saying? The area covering India's Punjab, Pakistan's Punjab, Chandigarh, Haryana, and Himachal Pradesh. Okay, this is roughly the Khalistan area that they are demanding. All right, so this is one thing. And second thing is the Unlawful Activities Prevention Act, UAPA. UAPA. Now, why are we supposed to discuss this? Because this guy's Panun's properties are confiscated by NIA under this act. Okay, so this was enacted in the year 1967. We'll see some basics. Okay. Now, what is an unlawful activity according to this act? The act defines it as any activity or action or association that intends to disrupt the territorial integrity and sovereignty of India. Then it is called as unlawful activity. Fine. And in 2004, there was an amendment and there was expansion of definition of unlawful activities. Prior to 2004, the unlawful activities primarily referred to actions related to only secession. Okay. And after 2004, that is after the amendment of 2004, terrorist activities were also added to the list of unlawful activities. Okay. So this one you have to remember. And third point is, central government has the absolute power to declare an activity as unlawful activity. All right. So these three are important points. And fourth one, the punishments under UAPA include severe punishments and death penalty, life imprisonment also. Okay. So these are some basics. Now we'll get into the MCQ. Consider the following statements with reference to UAPA. UAPA was enacted in 1967. Yes, we have seen in the basics. The central government under UAPA has the authority to declare an activity as unlawful through an official gazette. Yes, because according to the Act, the central government has absolute power. All right, now in the 2004 amendment to UAPA added Terrorist Act to the list of offences. Yes, this is also true. The Act allows for death penalty and life imprisonment as the highest punishments for those found guilty. We have seen in the basics, no, all these things. So all four are correct. Consider the following statements according to the Constitution of India. The central government has a duty to protect states from internal disturbances. This is true. Okay. According to Article 355, the central government has a duty to protect states from internal disturbances and from external aggressions also. Fine. Now, first statement is right. The Constitution of India exempts the states from providing legal counsel to a person being held for preventive detention. This is also true, and this is given in Article 22, Clause 3, Subclause B. Okay, so this is also true. According to the Prevention of Terrorism Act of 2002, confession of the accused before the police cannot be used as an evidence. See, this is false because if the confession is made before a police officer who is of the rank SP and above SP, then it can be considered as a proof or evidence. Okay, so 1 and 2 are correct. So 2 statements are right. Now we'll get into the next article. Unheeded advice. This article is about the tussle between the state governments and the governor. Okay, so this year this theme will become very, very important. Governors. This is the theme that will become very important for this year prelims. Okay, because it is repeatedly in news. All right. So what is the context? The state governments have approached the Supreme Court to address concerns about the way governors have used their discretion in granting assent to the bills. Okay. Why is it so? Because of the absence of a time frame for granting assent has allowed some governors to potentially harass and frustrate the elected regimes. Okay. So that is the context. You have to remember a few basics as we've discussed in the previous sessions also. That is Article 200 and Article 201. Now we'll learn it through the MCQ, all right? Now, consider the following statements with reference to Article 200 of the Indian Constitution. The governor can withhold assent from any bill passed by the state legislature except a money bill. This statement is wrong. The governor can give assent or can withhold the assent for a money bill, but he cannot return the money bill. This you have to understand very clearly. Okay, he can say yes or he can say no, withholding the assent, but he cannot return a money bill. So one is wrong. This is mentioned in Article 200. All right. Now, the governor can return a bill other than a money bill to the state legislature for reconsideration only once. This is true. The governor can assent to any bill that would undermine the powers of the High Court of the state and endanger its constitutional position. No, governor has to reserve such bills for mandatorily reserve such bills for the consideration of president. Now what the president will do to such bills, it is under Article 201. Okay, now what president can do, but the governor has to reserve a bill which is endangering or undermining the powers of the state high court. All right, so this is wrong. The governor can reserve any bill for the consideration of president if he or she deems it necessary. This is also true. This is also true. Okay, but he has to compulsorily or mandatorily reserve the bill for president if this is the case. Okay, so only 2 statements are right. Yeah. Which of the following are the discretionary powers given to the governor of a state? Sending a report to the President of India for imposing the president rule? Yes. Appointing the ministers? See, this is a function of the governor, but it's not a discretionary function. There is a difference, okay? The state governments, council of ministers and the chief minister are appointed by the governor as per Article 164. Okay, and he also appoints the advocate general according to Article 165. However, this is not discretionary power. Okay, so in the examination hall, you will think that, yeah, this is also power of the governor, this is also power, and you will mark everything. But no, they are specifically asking discretionary power. So with polity questions, please be very, very careful. With all the questions, you have to be careful. But polity, why? Because they are easy to crack if you pay attention. Okay, yeah. So this is a function, but this is a power, but it's not a discretionary power. So 2 is gone. When 2 is gone, D is gone, C is gone, A is gone. So 2 is the deciding factor here. So you don't need to read 3 and 4 because there's only one option left. So B is the answer. All right. Now, reporting animal cruelty makes children safer. So the article says that a 2019 study in the US, 2019 study in the US revealed that threats and violence towards animals were used in approximately 12% of the cases to coerce children into compliance and silence them about abuse. Okay, Children may be reluctant to report animal abuse for fear of repercussions. And in India, according to a 2007 study, there is so much of child abuse that every 2 out of 3 children experience physical, sexual, and emotional abuse. Okay, so here in prelims perspective, you need to know something about the act that is dealing with animal cruelty. All right, and that act is Prevention of Cruelty to Animals Act of 1960. All right, which established the Animal Welfare Board of India in 1962. And what is the function of this one? It is a statutory body to advise the government on matters related to prevention of cruelty to animals. Okay, so these are 2 points. And third point is it was started under the stewardship of Srimati Rukmini Devi Arundel. She is a first woman in Indian history to be nominated as a member of Rajya Sabha. So this also you have to remember, Srimati Rukmini Devi Arundel. All right. Now, what are the prohibited acts under this act? 1. Performing animals. This act, it regulates the exhibition and training of performing animals to ensure that they are not subject to unnecessary torture. Okay. And second, experimentation on animals. This act also regulates this for scientific or educational purposes. All right. And 3, transport of animals. This act also sets guidelines for the transport of animals to prevent their suffering during transportation. And the most criticized aspect of this act is the penalties part. Penalties part. If one is convicted or is found to be an offender for the first time under this act, then the punishment, monetary punishment, would be around 10 to 50 rupees only. Okay, monetary punishment. So this aspect is highly criticized. Okay, now I'll get into the MCQ. Which of the following statements are correct about Prevention of Cruelty to Animals Act of 1960? The act establishes the Animal Welfare Board of India, which is a statutory advisory body that advises the government on animal welfare issues. This is correct. The act exempts the killing of animals in a manner prescribed by religion from its provisions. This is also true. The Act specifies the maximum penalty for cruelty offences as rupees 10,000 or punishment for 6 months or both. No. We just saw, right? The highly criticized aspect of the Act. So, 2 statements are right. Okay. Which of the following are envisaged by the right against exploitation in the Constitution of India? Now, right against exploitation, there are 2 rights, no? Article 23 and 24. What is Article 23? Prohibition of traffic in human beings and forced labor. That is Article 23. And what is Article 24? Prohibition of employment of children in factories and mines. All right. So, here, first statement, prohibition of traffic in human beings and forced labor. It is 23, Article 23. Abolition of untouchability. It is Article 7. It is under right to equality. Okay, not right against exploitation. Okay, so 2 is gone. When 2 is gone, A is gone, B is gone, D is also gone. Again, here 2 is the deciding factor. Okay, you don't need to read 3 and 4. Alright, so C is the answer. Now, same sex couples, a judge to rescue. Now, what is this article saying, or what is the context? See, the Supreme Court in the Suprio versus Union of India case, Suprio versus Union of India case, did not recognize the right to marry or have civil unions for same sex couples. Okay, so the LGBTQIA plus community were disappointed because they were feeling excluded from the mainstream society. Okay, so that is the context. Now, Justice Venkatesh, he passed an order in Sushma versus Commission of Police. What does the order say? It proposes the creation of a deed of familial association. Deed of familial association. Now, what is this? See, deed of familial association means it ensures two persons will have the right to live in a relationship. Okay, so this is the context. Now, this word is also important. Deed of familial association. All right. Now we'll look into the MCQ. Consider the following statements with reference to LGBTQIA rights in India. Section 377 of the Indian Penal Code, which criminalized homosexuality, was struck down by the Supreme Court in 2018. In which case, it is Navtej Singh Johar versus Union of India case. Okay, so this case name is also important. Now, this is correct. Transgender people have the right to self identify their gender and obtain legal documents without any medical examination or certification. No, this is wrong. This is wrong. Okay, they need to undergo medical examination and then they will get a certification or whatever it is. Okay, now same sex marriage and adoption are legally recognized and protected in India. No, this is wrong, because if that was the case, why all these cases and why so much hustle? Okay, so only one is correct. All right, now, which article of the Constitution of India safeguards one's right to marry the person of one choice? It is Article 21. And you have to also remember a case here, that is Lata Singh versus the state of Uttar Pradesh. In this case, the court viewed that right to marry is a component of right to life. Okay, so B is the answer. Now, SC begins hearing on pleas against parties offering freebies during elections. Now, what is the context? The Supreme Court began hearing petitions seeking a judicial declaration that offering irrational freebies to voters during the election time should be considered as a corrupt practice. Okay. Now, what is a corrupt practice? What is a corrupt practice? In which act this corrupt practice with respect to this elections is defined? It is defined under section 123 of the Representation of Peoples Act of 1951. Okay, it's 123, not 143, the famous number. Okay, so this 123 you can remember, no? Yeah. Now, the court is also considering this section and to decide whether freebies can be deemed as a corrupt practice under this section or not. Okay. Now, what is Representation of Peoples Act of 1951? It is a law that governs the conduct of elections in India. All right. Now, we'll get to the MCQ. Consider the following statements in relation to the Representation of Peoples Act of 1951. It provides for the reservation of seats for women in the parliament and the state legislatures. This is wrong. It was provided through a constitutional amendment act. No, this is wrong. Okay. That is 106 Constitutional Amendment Act, also known as the Nari Shakti Vandan Act. No, so this is wrong. Now, it empowers the President of India to disqualify any member of either House of Parliament or of a state legislature on the recommendations of the Election Commission. No such thing is there. I mean, it does not empower the president. Okay, it defines various corrupt practices and electoral offences and prescribes penalties for them. Yes, we have seen, no? It regulates the registration of political parties with the Election Commission and their entitlement to accept contributions and declare donations. Yes, we have seen that corrupt practices are under section 123. Okay, so yeah, so two statements are correct. Only two statements. Okay, so B is right. Now, consider the following statements regarding the political parties in India. The Representation of Peoples Act of 1951 provides for registration of political parties. This is correct. So, C is gone. Registration of political parties is carried out by the Election Commission. This is also correct. Okay. So 2 is correct. So B is gone. Now 4 is common. So you don't need to read 4. Okay. Now third statement. A national level political party is one which is recognized in 4 or more states. This is also correct. And in addition to this, there are also other conditions. Okay. Either this or the candidates should have secured at least 6% of the total valid votes in at least 4 states, and the party has at least 4 MPs in the last Lok Sabha polls. Okay. Or the party must have won at least 2% of the total seats in the Lok Sabha from at least 3 states. Okay. So these are some conditions to be recognized as a national level political party. So 3 is correct. So D is the answer. All right. Now, next article. Thus flags model based lending warns banks, NBFCs of undue risk build-up, and it is relevant in GS3. Okay. Now, who is this Das? Shaktikanta Das. He is the governor of RBI now. Okay. So he is warning banks and NBFCs of undue risk build-up. Okay. Now, let us look into the MCQ. Consider the following statements with reference to non-banking financial companies in India. So, NBFC, what is NBFC? It is non-banking financial company. That's the full form. It is a company registered under the Companies Act of 1956. Okay, it is engaged in the business of loans and advances and acquisition of shares, bonds, securities issued by the government or local authority. That is one point. And second point is NBFC does not include any institution whose principal business is that of agriculture activity or industrial activity or purchase or sales of any goods other than securities or providing any services and sale and purchase of immovable properties. These are some basics you have to put it in mind. Now, NBFCs can accept demand deposits from the public. NBFCs cannot accept demand deposits. In addition to this, they cannot issue checks or provide deposit insurance like the banks. Okay, so these are the differences between NBFCs and banks. Okay, so this is gone. Now, NBFCs can issue checks and provide deposit insurance to their customers. No. NBFCs are registered under the Companies Act of 1956 and regulated by the RBI. Yes, we have seen, no? Companies Act. Yeah. NBFCs can offer loans, investments, insurance, leasing, hire purchase, chit funds, and other types of financial products. This is true. So only two statements are correct. All right. Now, with reference to NBFCs in India, consider the following statements. They cannot engage in acquisition of securities issued by government. See, this is wrong. Okay. They cannot accept demand deposits like the savings account. This is correct. This is one basic difference between bank and a NBFC, right? So B is correct. Only second statement is right. All right. This is it for today. All the best.